In a courtroom built on control, the man with the badge was the first one to lose it. He slapped a black woman in open court like no one there could stop him. But she did not raise her voice. She only steadied herself, while the court reporter in the corner kept writing, and before the deputy understood what that silence meant, the room had already begun to move against him. Who exactly had he just struck? By 9:13, courtroom 4B had already settled into the stale rhythm of another crowded morning. Cheap fluorescent light flattened every face in the room. Paper folders slid across counsel tables. A clerk called names without looking up. The judge had not taken the bench yet, but the room still carried that heavy, obedient silence people wore when they knew one wrong move could draw attention they did not want. Near the front rail stood a black woman in a plain navy blouse and dark slacks, one hand resting on a worn leather folder, her posture straight, her expression calm. She looked tired, but not broken. She looked like someone used to holding herself together in rooms that offered no kindness. Beside the aisle, Deputy Mercer watched her the way some men watched anything they believed they could control. His hand stayed near his belt, his jaw tight, his eyes full of casual ownership. When she asked the clerk a quiet question about where to stand, Mercer answered before the clerk could speak. His voice was low, hard, and needlessly sharp. From that moment, the whole room could feel it coming. Something ugly had already decided to happen there that morning. The woman turned slightly, not away from him, just enough to show she had heard the order and meant no trouble. "I'm only asking where counsel said I should wait," she said, calm enough to make his aggression look even uglier. Mercer stepped closer anyway, boots hard on tile, shoulders squared. The kind of movement meant less to control a room than to remind one person she was supposed to feel small inside it. For one suspended second, nobody breathed. Then his hand flashed. The crack of the slap bounced off wood paneling and marble like a gunshot disguised as discipline. Her head snapped to the side. The leather folder slipped from her hand and struck the floor with a soft, helpless sound. No one moved. A bailiff near the rear door froze. A young attorney half rose, then stopped. Even the clerk finally looked up. The woman touched her cheek once, more in surprise than panic, and lifted her chin again. Her eyes glistened, but her voice did not shake. "You struck me," she said into the silence, as if naming the truth mattered more than the pain itself. That was the moment the room stopped belonging to him. Mercer realized too late that everyone was staring, and instead of stepping back, he reached for authority like a drowning man grabbing chain. He barked that she was being disruptive. He said she had failed to comply. He warned the room not to interfere with courtroom security procedure, as though the right words could turn what they had seen into something official and acceptable. But the silence had changed. It was no longer passive. It was watchful, dangerous. The woman did not argue. She did not raise her voice. She only asked for his name and badge number, each word measured, impossible to mishear. Somewhere near the back, a phone lowered slowly. Near the clerk's desk, someone wrote down the time. A prosecutor avoided Mercer's eyes. The bailiff by the rear door shifted, not toward the woman, but away from Mercer. For the first time, uncertainty touched his face. He had expected fear, maybe tears, maybe confusion. What he got instead was witnesses finding their courage one movement at a time. Then the courtroom door opened, and a court administrator stepped in fast, looking at Mercer, not her. Whatever protection he thought the room would give him was gone. Mercer moved first, because men like him always understood the value of speaking before anyone else could think. He pointed at the woman as if outrage itself were proof of danger. She became aggressive, he said, voice louder now, aimed as much at the arriving administrator as at the room. She refused repeated instructions. "I use minimum force to maintain order." The words came out smooth, practiced, almost bored. That made them worse. He was not panicking yet. He still believed the building would absorb his version simply because he wore the badge. The administrator hesitated. So did the clerk. No one wanted to be the first person to openly challenge a deputy inside his own courtroom. Mercer kept going, building the lie while the shock was still fresh. He called her unstable. He implied she had lunged. He suggested the room had been seconds from losing control. Each sentence tried to drag her dignity through the mud before she could defend it. Around the benches, people looked at one another, angry but uncertain. The room had seen the truth. The question was whether truth mattered more than uniform and routine, power, habit, fear, and silence. For years before this, the woman did not match his volume. She bent once, picked up her folder, and steadied it against her side before speaking. "State your full name and badge number for the record," she said. Clear, even, unhurried. Mercer stared at her, caught off guard by the precision. She turned to the administrator next. "I need medical attention documented. I need witness names preserved. I need confirmation that this incident will be included in the official court log." The room changed again. This was not panic. This was procedure. "I also want confirmation," she continued, "that any hallway, entry, or courtroom recording from the last 10 minutes is preserved immediately." The clerk looked up sharply at that. A young attorney near the rail straightened, suddenly listening with his whole face. The woman touched her cheek only once, then lowered her hand as if refusing to let pain narrate the scene for her. "Please identify everyone present who observed physical contact," she said. Mercer's confidence flickered. He had expected tears, maybe anger, maybe a plea. Instead he got structure, language, and a woman who sounded like she knew exactly how systems failed and how to trap them before they did. That was when the room quietly began refusing him. The clerk, who had frozen before, pulled the incident ledger closer and wrote down the exact time. The young attorney who almost stood during the slap stepped into the aisle and offered his name as a witness without waiting to be asked twice. At the rear, a bailiff avoided Mercer's stare and confirmed that contact had occurred. A spectator whispered seat numbers to another. Someone near the door repeated the administrator's arrival time. No one made a speech. No one turned heroic. But details began locking into place with the stubborn force of people who understood that memory could be bullied unless it was fixed quickly. Mercer tried to interrupt, saying statements should wait, saying procedure required control, saying the woman was manipulating the room. Yet every new note, every exchanged glance, every small act of record-keeping made his voice sound thinner. The administrator finally asked the clerk whether security cameras covered the entrance corridor. Before the clerk could answer, another staff member appeared at the doorway, already whispering that presiding Chambers had heard there was an incident in for B. The story had left the room now, and Mercer knew it before this story unfolds. Like and subscribe to Court of Karma, where hidden truth rises. Power falls, and justice always finds its voice. Outside courtroom for B, the hallway filled faster than anyone wanted to admit. Doors stayed half open. Clerks paused mid-step with files tucked to their chests. A court reporter leaned toward the wall phone, whispering carefully to be casual. Mercer came out first, talking before questions could reach him, telling anyone within earshot that the woman had disrupted proceedings and forced his hand. He said it with that same controlled edge, trying to plant certainty before doubt could spread. But the woman emerged behind him with the administrator at her side, one hand pressed lightly to her cheek, posture straight, face composed. That contrast did more damage than argument ever could. In the Clark area, two narratives started racing each other at once. Mercer's version moved through rank, instinct, and habit. Hers moved through observation, memory, and the unease of people who knew what they had seen. Chambers staff stepped into the corridor. Someone asked whether the judge had been informed. Someone else asked whether the deputy had touched a litigant, a witness, or a visitor. Every answer seemed to matter. Then a senior clerk said the words that changed the pace of everything. Preserve the recording before anything is overwritten. That single sentence pulled the incident out of rumor and into machinery. The clerk at the terminal checked the courtroom audio cue. Another staffer called downstairs to ask how many hallway cameras covered the entrance to B. The court reporter marked the interruption time against her notes. The administrator asked where the woman had been standing, where Mercer had been standing, and who had clear sight lines from the benches. A young attorney pointed to the exact spot near the rail where the folder had fallen. The bailiff from the back door confirmed the direction of the strike with a shaky voice that sounded more honest because of it. Even the seating chart, usually forgettable, became useful now. It showed who sat close enough to see the angle of Mercer's arm. It showed who could confirm distance, posture, movement. Mercer tried again, saying the cameras would not tell the full story, saying video never captured threat the way trained officers could feel it. But each practical detail made his claims smaller. Logs existed, audio existed, witness placement existed, timestamps existed. The building had started steadily building a case without asking his permission, and he could feel control leaving his hands. Then the most dangerous fact of the morning surfaced almost by accident. The administrator, still listening to two people at once, asked whether standards had arrived for the scheduled observation. A clerk answered yes before realizing what that meant in front of Mercer. This was not an ordinary court day. For the last 3 days, the courthouse had been under live compliance review, tied to a mandatory training cycle on courtroom conduct, force boundaries, bias response, and public contact procedure. Outside evaluators were in the building. Supervisors had been warned all week to tighten behavior, document incidents carefully, and avoid any unnecessary confrontation. Mercer stared as if the floor had shifted under him. The woman did not react beyond a slow blink, but people around them did. A chamber's assistant stopped writing and looked up. The young attorney let out one stunned breath. Somewhere down the hall, another door opened with purpose. This was no longer a deputy's word against a civilian's. He had created a live example of exactly what the courthouse was being reviewed to prevent. Then the administrator's phone vibrated. She looked at the screen, lifted her eyes, and said, "Training and standards are on their way now." They arrived without drama, which made them more intimidating. No raised voices, no rushing boots. Just 3 people in dark courthouse jackets marked standards and training, moving through the hallway with the steady focus of people who did not need to perform authority because they already had it. The lead investigator, a grey-haired woman with rimless glasses and a tablet tucked under one arm, looked first at the woman's cheek, then at Mercer, then at the administrator. Her expression never changed. Mercer started speaking immediately, trying to seize the narrative again, but she lifted one hand and silenced him without a word. That small gesture did what the badge no longer could. Behind her, a younger compliance officer opened a case file and began noting names, times, and positions. The third member spoke quietly into a phone, alerting Central Records that a use of force review had just become active. No one asked Mercer how he felt. No one softened the moment for him. They were not there to defend uniforms or soothe egos. They were there to measure failure. And from the instant they entered the corridor, the building seemed to accept that control had changed hands completely now, for good. Courtroom 4B stopped functioning as a courtroom and became a scene. Proceedings were frozen. The judge was instructed to delay entry. Doors were limited, hall traffic redirected, and witness movement controlled before casual conversation could blur recollection. One officer moved to preserve hallway footage, courtroom audio, and adjacent camera feeds. Another separated the clerk, the bailiff, the attorney near the rail, and the spectators closest to the strike so each statement could be taken cleanly. The administrator was told not to summarize, only to document. Mercer tried objecting, saying this response was excessive, saying the matter could be handled by his supervisor, saying he was being treated like a suspect. The lead investigator finally looked at him and said, "At this point, Deputy, you are the subject of a live standards event." The hallway went still. Even Mercer seemed to hear the weight of that phrase. This was not routine discipline. This was institutional containment. The woman was offered a chair, water, and medical review. Evidence tags were assigned to audio, notes, and the dropped folder. The slap was no longer a moment someone might minimize later. It had become a documented failure unfolding in real time. Inside this courthouse, Mercer grew louder as the process tightened around him. His words came faster, then less carefully. He repeated non-compliance too often. He kept saying threat perception without matching it to anything the witnesses had described. Sweat had gathered along his hairline now, and anger was beginning to leak through the professional tone he had tried so hard to maintain. Across from him, the woman stayed composed enough to make every contrast brutal. A medic lightly examined the swelling along her cheekbone while she answered questions in short, exact sentences. Where she had stood, what she had asked, which hand struck her, where her folder landed, who was facing the rail. She never exaggerated. She never guessed. When she did not know something, she said so plainly. The lead investigator watched both of them with the kind of silence that compared people more honestly than argument ever could. Mercer looked like a man trying to outrun a record already being written. The woman looked like someone helping it become accurate. Then the younger compliance officer paused over his notes and quietly asked the administrator whether Mercer had been named in any prior conduct memos before this morning, in writing at all. The question changed the hallway. Until then, the morning had been about what Mercer had just done. Now it became about what people had already chosen not to stop. The administrator hesitated only a second before answering that there had been concerns. Not formal discipline, not anything that forced action, but notes, memos, quiet warnings passed upward and then folded into routine. A compliance officer requested Mercer's internal file, and within minutes a supervisor arrived holding himself too stiffly to look calm. His face gave away what his words tried to conceal. There had been prior complaints about tone, escalation, and unnecessary physical proximity with women in stressful hearings. One attorney had once reported that Mercer liked to crowd people until they reacted, then cite the reaction as justification. A clerk had noted that he spoke differently to certain visitors than to others, especially when he believed they lacked status or backing. None of it had been enough on its own to force the courthouse to act, but laid beside the swelling on the woman's cheek, those fragments stopped looking isolated. They started looking like a map everyone had pretended not to read for years on purpose before today there. Once the file was opened, memory stopped protecting anyone. Supervisors who had once called Mercer rough around the edges now had to explain why roughness kept appearing in writing. One lieutenant admitted there had been coaching conversations after 2 prior incidents, but no formal escalation because Mercer was considered effective under pressure. Another said complaints about bias were difficult to prove and often came from tense courtroom moments where emotions ran high. The lead investigator let those explanations sit in the air just long enough to sound rotten. Effective had become the word they used when they meant useful. Difficult to prove had become the phrase they hid behind when they did not want conflict inside the ranks. Reports had been softened, language trimmed, patterns broken into isolated moments small enough to ignore. Aggression became command presence. Intimidation became stress management. Bias became communication style. Every euphemism now returned like evidence of its own. The woman's case was forcing leadership to look at the difference between failing to know and choosing not to know. And once that difference became visible, the hallway felt heavier, because Mercer no longer looked like a lone problem at all anymore either that day. The next blow to Mercer's confidence came from someone he clearly recognized. A middle-aged court clerk from another floor stepped into the holding area after being called by standards, her hands tight around a notebook she had kept for years. She did not look angry. She looked tired of being right too early. She said Mercer had once shoved a visitor's paperwork back across a counter and leaned so far into the men's space that security had to redirect the exchange. She said he liked targets who appeared alone, uncertain, or already under pressure. Then a former public defender, still in the building on another matter, asked to make a statement too. She remembered Mercer grabbing a young mother by the elbow during a custody hearing and later claiming the woman had moved suddenly. The wording was too familiar. The posture was too familiar. Even the excuse sounded recycled. Mercer tried to interrupt, but nobody stopped them this time. Each new account stripped away another layer of accident, leaving behind habit. For the first time all morning, he stopped arguing and listened, because he understood that he was no longer defending a slap. He was defending his whole career now. Mercer asked for the chance to give a statement, and once he had the room's attention, he tried to rebuild himself with language. He said he had perceived movement. He said the woman's angle suggested escalation. He said he acted to protect courtroom order and judicial process. The words sounded polished, but something had changed beneath them. Each excuse arrived too late, like a script retrieved after the scene had already collapsed. When asked what movement he feared, he described one so vaguely it could have meant anything. When asked why no one else in the room reacted as if danger existed, he blamed their lack of training. When asked why he did not issue a verbal warning first, he said time did not permit it. That answer landed badly. Everyone knew there had been time. Time for him to step forward. Time for him to glare. Time for him to choose humiliation before impact. He kept reaching for phrases like split-second judgment and maintaining compliance, but those phrases sounded like hiding places. The more Mercer defended himself, the more obvious it became that every path in his story led back to the same thing. He wanted control, not safety. Standards dismantled him without emotion. The compliance officer pulled up the hallway camera first, then the courtroom angle, then the audio marker tied to the clock's lock. Mercer had claimed a sudden threat, but the footage showed distance, pause, and approach. The woman's shoulders were level. Her hands stayed visible. Her voice, caught on the room feed, never rose above a controlled question. Mercer moved before she did. He closed the space. He lifted his arm. He struck. Then policy entered the room like a second witness. The lead investigator read the force guideline aloud. Physical contact required a safety risk, clear verbal direction when possible, and the least intrusive response available. Mercer had failed every line of it. Witness statements tightened the net further. The attorney near the rail used the phrase, open hand. Strike, the bailiff said. No forward movement from her at all. The clerk noted that Mercer answered a placement question with hostility before the slap occurred. Even the timing hurt him. Less than 4 seconds passed between her words and his hand crossing her face. There was no confusion left, only sequence. And sequence was killing the story Mercer had tried to build from fear.py then. The strongest evidence against Mercer was not only what the room had seen. It was what the woman had refused to become. She had not shouted over him, lunged at him, cursed at him, or fed him the disorder he kept pretending to manage. Every witness described the same thing. She stayed grounded, asked where to stand, answered in a normal tone, and reacted to being struck with restraint that made the violence look even more deliberate. The medic noted swelling, not aggression. The administrator noted clarity, not instability. The lead investigator noted consistency across every retelling. Mercer had built his defense around the hope that force could be explained by chaos, but there had been no chaos until his hand created it. That truth settled over the hallway with the finality of a locked door. For the first time, even Mercer seemed to hear himself the way everyone else did. Repetitive, cornered, and afraid. The woman asked one more question. What happens next? She said. The lead investigator looked at the file, then at supervisors, and her answer came without hesitation. Fact collection is complete, she said. We are moving now to recommended actions and immediate consequences. The shift in tone came so fast it would have been funny if it were not so revealing. The same supervisors who had spent years sanding Mercer's edges into acceptable language now spoke about him as if he were a problem that had just appeared that morning. No one called him reliable now. No one mentioned pressure, instincts, or difficult court days. Instead, they used words like incident exposure, policy breach, operational liability, and immediate separation of duties. It was the language institutions used when loyalty became too expensive. Mercer stood a few feet away, hearing himself translated from colleague to risk. A lieutenant who had once defended him as forceful but manageable now refused to meet his eyes. Another supervisor carefully explained to standards that the courthouse took public contact failures seriously, as though seriousness had been missing until witnesses, cameras, and compliance officers forced it into the room. The woman watched in silence, her cheeks swollen, while the men who had once protected one another began protecting the building from him instead. It was bitter to watch because the shift was not moral awakening. It was survival, and everyone in the hallway understood that survival stopped with one sacrifice. Training leadership did not let the courthouse hide behind a single bad actor for long. Once Mercer was isolated, the lead investigator began naming the larger failures with calm precision. Bias recognition had failed before force did. De-escalation had failed before contact did. Complaint handling had failed long before this morning, when earlier warnings were softened into coaching notes and passed along without consequence. Reporting culture had failed by teaching staff that troubling behavior should be managed quietly unless it became impossible to ignore. Even courtroom design and staffing came under review. Who had authority to interrupt a deputy? Who controlled access to footage? Who documented visitor complaints? who had been trained to challenge misconduct without risking retaliation. The hallway fell quieter with every point because each one widened the blame. Mercer was no longer the whole story. He was the clearest symptom. The woman's case had become proof that the courthouse did not merely contain a violent deputy. It had trained itself to absorb warning signs until one of them exploded in public. That realization gave the morning a different weight. This was no longer revenge. It was an audit of the entire culture that had made him possible. The actual removal happened without ceremony, which made it feel more final. Mercer was instructed to surrender his courtroom post immediately, step away from the public corridor, and hand over his access card, radio, and duty assignments pending formal review. For 1 second, he looked as though he might argue again, but even he could hear the room had moved beyond him. A senior officer unfastened Mercer's credentials from his belt with the impersonal care of someone processing evidence, not helping a co-worker. Staff members along the hallway pretended to focus on papers, but their eyes kept lifting. They had all seen him command rooms before. Now they watched authority peel off him piece by piece. The woman did not smile. She did not need to. Her calm presence made the moment heavier than celebration ever could. When Mercer was escorted toward the service corridor, no one cleared space for him the way they once might have. The lead investigator then informed supervisors that this action was only temporary containment. A formal disciplinary hearing would be convened, witness packets prepared, and standards findings presented to a review panel before the week was over. With recommendations entered into the record immediately, the hearing was held 3 days later in a review chamber that looked almost too plain for what it had come to represent. No jury box, no public benches packed with strangers, just a long table, a wall clock, sealed packets, and the kind of official quiet that made every chair scrape sound important. Mercer sat on one side with union representation and the posture of a man trying to appear steadier than he felt. Across from him sat standards, court leadership, and the review chair, whose job was not to rescue anyone's pride but to turn uncertainty into record. The woman was present too, not at the center of the room, but impossible to ignore. The swelling had faded into discoloration, but the memory of that slap seemed sharper here than it had in the hallway. Mercer no longer controlled doors, movement, or tone. He had to wait to be addressed. He had to answer when asked. For the first time since that morning, the power arrangement matched the truth. The review chair opened the session, stated that the purpose was to determine factual findings and disciplinary outcome, and then said the sentence Mercer had spent days dreading. This proceeding concerns an unprovoked open hand strike committed by a deputy officer inside active court space. Once the evidence began, the room stopped feeling like a place where stories competed. It became a place where one story survived. The audio played first. Her voice came through steady, asking where she was supposed to stand. His came after it, sharp, hostile, already escalating. Then came the video. Not dramatic, not cinematic, not grainy enough to create doubt. Just clear enough. Mercer stepping in. Mercer closing distance. Mercer lifting his hand. Mercer striking her before any threat existed. The review chair did not rush. Each witness statement was read with the same care, which somehow made them hit harder. The attorney near the rail described the strike exactly. The clock confirmed timing and tone. The bailiff's account matched the camera angle. Prior notes were entered not as rumor, but as context the institution had failed to respect. The medic confirmed visible injury. Standards read the force policy line by line and paired each line with Mercer's violation of it. No one raised their voice. No one embellished. That was what made it feel final. The truth did not need help anymore. By the time the last document was entered, the room no longer looked divided. It looked embarrassed that it had ever allowed ambiguity to live there at all. Mercer was given the floor last, and the room seemed to know before he spoke that it would not save him. He tried anyway. He said the video did not capture perceived tension. He said courtroom security required rapid judgment. He said he regretted how the moment looked, which was as close as he came to admitting what it was. He talked about stress, responsibility, incomplete context. He talked around the woman without once naming her dignity or his own choice. Even his apology, when it finally came, sounded aimed at consequences instead of harm. The review chair let him finish, then asked a single question. Can you identify any action by the complainant that justified physical force under policy? Mercer opened his mouth, closed it, and looked at the table. That silence answered better than anything he had said all week. The ruling followed without suspense. Sustained misconduct, unjustified force, force post-incident reporting, immediate termination recommendation, decertification referral, and full forwarding of findings to the appropriate oversight body. Mercer's face emptied before anyone told him he could leave. Then Standards pivoted with almost brutal efficiency. A reform directive would follow. Training failures, reporting gaps, and supervisory neglect would be addressed in writing. Punishment had been made official. Now the institution had to prove it understood why. By the end of the week, Mercer's fall was no longer described as pending. It was active, documented, and expensive. His courtroom assignment was permanently revoked. His termination recommendation moved forward with supporting findings attached, which meant the record would follow him beyond one building and into every review that came after. Standards referred the case for decertification, opening the path that could strip him of the authority he had once worn like a private weapon. Because the hearing found false reporting as well as unjustified force, internal discipline was no longer the only danger. Oversight authorities received the file, and with it the possibility of additional civil and criminal exposure. His name entered databases where future employers would not see a misunderstanding. They would see sustained misconduct. They would see force used without lawful basis. They would see a deputy who hit a woman in open court and then tried to lie his way out of it. That was the difference now. The cost was not symbolic embarrassment or temporary leave. It was career damage, public record, financial risk, and the slow collapse of every professional door he had assumed would stay open for him forever, without consequence there. But Standards did not allow the courthouse to frame justice as one man being removed. The written reform order came next, and it reached into every layer that had failed before the slap. Mandatory retraining was imposed on all courtroom deputies assigned to public contact posts, with special focus on force thresholds, bias recognition, de-escalation, and documentation ethics. Supervisors who had softened earlier complaints were placed under formal review, their own decisions examined line by line. New protocol required immediate escalation of civilian misconduct complaints outside the normal chain when force was alleged. Camera preservation rules were tightened. Witness logging became mandatory in any disputed contact event. Clerks and attorneys were briefed on how to trigger protected reporting without waiting for a supervisor's permission. Most striking of all, court leadership issued a public acknowledgement that the failure had not begun with Mercer's hand. It had begun with tolerated behavior, minimized warnings, and a culture that mistook silence for stability. For the first time, the woman's pain was being translated into structural change. The building was not only punishing what happened, it was being forced to admit how it had helped it happen, for years, in plain sight. Before this morning arrived, when she finally spoke after the ruling and reform order, she refused to become either a symbol or a performance. She did not thank the courthouse for doing what it should have done in the first place. She did not offer the kind of soft forgiveness institutions sometimes hope will make their failures feel cleaner. Instead, she stood with one hand on the same worn leather folder and said she wanted the record to stay accurate. She wanted no private outreach from Mercer, no unofficial mediation, and no language that reduced the slap to an incident if the truth was assault. She said what mattered most was that no one after her be told to stay quiet for the sake of order. The room listened differently now, not because she was louder than before, but because it had finally learned the cost of overlooking her. In that moment, she became fully visible, not as a case file or injured party, but as the moral center of the entire story. Yet even with rulings entered and reforms announced, one thing still remained. Punishment had closed around Mercer. Closure had not fully reached her yet, not in the quiet places afterward either. A week later, courtroom for B looked almost the same until you stayed long enough to notice what had changed. The same benches faced forward. The same rail divided the room. The same fluorescent light flattened oak paneling into dull gold. But the atmosphere no longer carried that old, lazy confidence that authority would always be believed before anyone else. New notices sat near the clerk's station explaining complaint reporting and witness protections. A camera status light that nobody used to notice now seemed impossible to ignore. Deputies moved with a new carefulness, less swagger, more awareness of being seen. Even the silence felt different. It was not the silence of people afraid to be noticed. It was the silence of a room that had learned what could happen when the wrong person was trusted too quickly. When the woman stepped back inside to retrieve a certified copy of the final record, no one barked at her, redirected her sharply, or acted as though she needed permission to occupy the air. The room where she had been struck still existed, but it no longer felt like his space. It felt, finally, like a place forced to fully remember what happened there. She stood at the same front rail for only a moment, one hand resting on the worn leather folder that had fallen when Mercer struck her. The bruise had faded. The memory had not in the slightest anymore. Still, nothing about her presence suggested fragility. She was composed in the way certain people become after surviving something that was meant to shrink them but failed. The clerk handed over the certified papers with both hands and addressed her carefully, almost respectfully, as though language itself mattered more in that room now. She thanked the clerk, not warmly, not coldly, just clearly. Then she looked across the courtroom once, taking in the benches, the empty deputy post, the polished floor where her folder had landed, and the door through which Mercer had been led away. She did not need to say much because her presence was already saying it. He had tried to define her with one violent act. He had tried to turn her into a problem, a disturbance, a body to command. Instead, she remained exactly what he could not control, steady, self-possessed, and entirely untouched in spirit by the story he had wanted to write over her. That was the lesson the courthouse learned too late. The person it treated as easiest to dismiss had become the one who exposed how fragile its habits really were. Mercy's slap had been meant to silence, reduce, and dominate in one quick motion. Instead, it triggered the very process he thought his badge could outrun: scrutiny, training, exposure, punishment, and change. The building had tried for years to smooth over warning signs, to rename aggression, to protect its comfort by ignoring its conscience. But truth had entered through the person they assumed held the least power. She had not needed to shout the system down. She only had to stand still long enough for it to reveal itself. And the witnesses had to live with that truth. By the time she left courtroom for B with the final record in her folder, the story no longer belonged to the deputy, the supervisors, or even the courthouse. It belonged to the fact that dignity survived them all. The hand meant to humiliate her had instead marked the end of someone else's authority. And in the quiet after everything, that felt less like revenge than justice. Late, costly, and finally impossible to deny.